The law of obligations has, as is well known, two main branches, that of voluntary agreements, contract, and that which concerns obligations that arise as a result of a duty of care owed, tort. Inherent in the first branch, that of contract, is the concept of consent. While, however, the concept of consensual bargaining is central to our understanding of contractual obligations, the courts have been reluctant to set aside contracts. This is especially the case when consent is affected by power differentials in contractual bargaining. For instance, it is difficult to set aside contracts between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to exact agreement, and in certain circumstances, courts will set aside apparent contracts. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law were slower to develop a response to the use of illegitimate pressure, but do now recognize, under the doctrine of duress, to render a contract voidable where one party has employed illegitimate pressure during the contractual process. Both duress and undue influence represent situations in which someone has not entered into a contract as a result of their own free will. The choices have been interfered with in some way, which means that their decision to enter into an agreement has resulted from coercion. Proving that this has occurred, however, is usually difficult, as in some situations the pressure placed on one party by the other can be subtle, and therefore this is one area where presumptions are used as part of the legal arguments establishing a lack of free will. The outcome of successfully arguing that the free will of one party has been coerced is giving the coerced party the freedom to escape the contract, and therefore agreements in this area will be voidable at the discretion of the victim. This presentation deals with these two key ways of addressing lack of propriety in contractual bargaining. We start with a discussion of the doctrine of duress before moving on to a consideration of undue influence. A key assumption in all discussions on contractual negotiation is that any agreement is the result of a voluntary action of the parties. As mentioned at the beginning of the presentation, generally, courts are reluctant to set aside a contract between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to exact agreement. Who the weak party will be in the types of business contracts we're discussing here will obviously depend on the circumstances. For instance, a landlord will normally be in a stronger position than a tenant in a contract for a domestic tenancy, but the opposite may be true in the case of commercial premises where there may not be a wide range of alternative tenants. As an illustration, consider the frequent use of company voluntary arrangements, or CVAs, where a controversial form of insolvency is being used by a growing number of struggling high street chains. These are employed to entice property owners to accept lower rents to help a tenant avoid financial collapse, and are seen by many landlords as attempts by tenants to avoid their rental obligations. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law, under the doctrine of duress, can render a contract voidable where one party has employed illegitimate pressure during the contractual process. The law encompasses duress to goods and, more recently, economic duress. Duress renders the contract voidable rather than void. The apparent consent of the victimized party is treated as revocable. They have the ability to affirm or not to affirm the contract. If they choose not to affirm the contract, it is void. See Universe Tankships of Monrovia versus International Transport Workers Federation, the Universe Sentinel from 1983, Pao On versus Lao Yiu Long from 1980. The effect of finding that duress renders a contract voidable has several important consequences. For example, the party subject to the duress must act promptly to set aside the contract. See North Ocean Shipping versus Hyundai Construction from 1979. And a third party can acquire good title to goods even though his vendor has acquired those goods pursuant to a contract which was brought about by duress. Initially, only duress to the person, a threat to the personal security of an individual, as in Barton versus Armstrong from 1976, was recognized as duress. Gradually, the law expanded to encompass duress to goods and, more recently, economic duress. There is even some support for the position that duress renders a contract void amongst the academic commentators, especially when duress is to the person. However, the prevailing view is that duress renders the contract voidable rather than void. The apparent consent of the victimized party is treated as revocable. Duress to the person occurs when one party to a contract forces another to contract with them through threats of violence. Where a party enters into a contract for several reasons, of which the duress is only one reason, the contract is still voidable. See Barton versus Armstrong from 1976. Duress to goods may occur where one person threatens to destroy or take the goods of another unless a contract is entered into. Duress to goods was recognized in the case of the Ciboen and the Cibotree from 1976. Economic duress, as such, was recognized in Pao On versus Lau Yu Long in 1980 and in the Universe Sentinel in 1983. Economic duress occurs when one party uses its superior economic power to force the weaker party into an agreement. The main difficulty in this area is to draw the line between unacceptable commercial pressures, which amount to economic duress, and acceptable commercial pressures, which do not amount to economic duress. Duress exists when there is an illegitimate threat to perform an act unless the other party enters into a contract or varies an existing contract. Consent must be vitiated. Lord Hoffman, in R versus Attorney General for England and Wales in 2003, stated that the wrong of duress has two elements. First, pressure amounting to compulsion of the will of the victim, and the second was the illegitimacy of the pressure. Acceptable and unacceptable commercial pressures is explained in the speech of Lord Scarman in Pao On versus Lau Yu Long in 1980. The following are used in determining whether or not there was a coercion of the will so as to vitiate consent. First, did the person who was allegedly coerced protest at the time? Second, did this person have an alternative course of action open to him, such as an adequate legal remedy? Third, was the person independently advised? Fourth, did the person take steps to avoid the contract once they had entered it? Shinkari versus Gallagher from 1994. Let us consider these requirements in a bit more detail. In summary, a finding of economic duress will rest on proving three core elements. That 1. A threat was made, 2. The threat was illegitimate, and 3. A contract was concluded, but the threat affected the decision-making of the party in the sense that they did not enter into this contract exercising free will. Explaining the threat. First of all, a threat needs to be made. Pressure arising from unfortunate circumstances is not enough. However, threatening to carry out an action that is perfectly lawful would not be seen as forming part of duress. For example, in Williams versus Bailey, the case concerned a threat of being lawfully imprisoned. In DNC Builders versus Rees, the case illustrated an illegitimate threat in the agreement to accept less. In the Universe Sentinel in 1983, a trade union refused to provide tags to tow certain ships out of harbor unless certain payments were made to its welfare fund. Without the tags, the vessels would not have been able to sail, and this resulted in the ship being effectively blacked, a term meaning that the trade union's members would not deal with it. They claimed that they were entitled to make such demands because they were protected by the Trade Union and Labor Relations Act of 1974. They claimed that the money was extracted as part of a labor dispute with the Act. The court held that the availability and eligibility of the welfare fund to employees was not connected to their terms and conditions. Therefore, the union's actions amounted to illegitimate pressure. However, it would be wrong to equate illegitimate with unlawful. In Al-Nehayan versus Kent in 2018, the claimant claimed from the respondent amounts due under a promissory note and a joint venture agreement. The respondent alleged that his consent to the agreement and the note was obtained by unfair means, including threats of physical violence and economic duress. Lord Justice Leggett restated the law on duress at, quoting, Times Travel versus Pakistan International Airlines from 2017. There can be no doubt that even a threat to commit what would otherwise be a perfectly lawful act may be improper if the threat is coupled with a demand which goes substantially beyond what is normal or legitimate in commercial agreements. There is no reason the distinction between lawful and unlawful behavior should be decisive on whether the respondent can retain money or other benefits demanded from a claimant in a situation of extreme vulnerability. It is appropriate to take account of the legitimacy of the demand and to judge the propriety of the defendant's conduct by reference not simply to what is lawful, but to the basic minimum standards of acceptable behavior. In summary, therefore, a demand coupled with a threat to commit a lawful act will be regarded as illegitimate if, first, the defendant has no reasonable grounds for making the demand. The threat would not be considered by reasonable and honest people to be a proper means of reinforcing that demand. The doctrine of duress could be interpreted as being based not on lack of consent, but on showing that the party's consent was obtained in circumstances which make it unjust to allow the other party to enforce the agreement. Therefore, that legal advice was taken or rational or independent judgment exercised in entering into a contract does not preclude the finding of duress. What is necessary is that the illegitimate pressure caused the claimant to enter into a contract. As to causation, violence causes a party to enter a contract if it is one reason for entering it. With economic duress, the but-for test applies. It is not necessary that the claimant had no reasonable alternative to giving in to the illegitimate pressure. What is required is very strong evidence of whether the claimant was induced by the threat or other illegitimate pressure to enter into the contract. This is also a relevant factor in deciding whether the use of pressure was illegitimate, even though there is no illegality. Examining the contract. There has to be an effect seen as a result of the threat. If duress is about showing the will of one of the parties has been subverted in some way, there has to be a link between the decision to enter the contract and the threat made. In Barton v. Armstrong from 1976, a former chairman of a company threatened the managing director with death if he did not transfer money for a large sum of money. However, the argument in court to strike out the transaction for duress failed because there was some evidence that the managing director believed this to be a good deal and, although he felt apprehensive about himself and his family's safety, this did not affect his judgment, and so his decision to enter into the contract was one that involved his exercise of free will. It was therefore difficult to show that the threat had affected his decision-making such that it could be thought of as duress. Examining consent. The effect of duress is that it negates the will of the parties, but this is subject to some interpretation. Negating of consent does not have to be total but can be satisfied if the alleged victim is required to choose between the lesser of two evils. In DNC Builders in 1966, the creditor had a choice of either accepting the money and the revision to the agreement or suing the other party for breach of contract. However, as in financial difficulty, they did not have the time or resources necessary to pursue a claim in the courts. Therefore, there was duress present because it required them to choose under the constraints imposed by the threat. In order to find affected consent, therefore, we can look for situations where a party to a deal has no realistic choice. While the common law doctrine of duress is concerned with the procedure by which a contract was agreed, the equitable doctrine of undue influence is focused upon the relationship between the parties. Equity acts upon the conscience, and the equitable doctrine of undue influence operates where the people are in a relationship where one party relies upon the other. The court in Royal Bank of Scotland v. Ettridge, No. 2, in 2001, described the doctrine as one of the grounds of relief developed by the courts of equity as a court of conscience. It is something that stops short of duress, as a specific threat made against the other party is not required. We could summarize the doctrine by saying that undue influence arises because of a subtle influence that one person has over another, when one person occupies a position of power over the other party and can use that position to influence the other party to enter into a contractual agreement. The objective is to ensure that the influence of one person over another is not abused. In the past, courts divided undue influence into two categories: actual undue influence and presumed undue influence. Royal Bank of Scotland v. Ettridge re-explained what was meant by this division. In one instance, undue influence was presumed as a matter of law by reason of the type of relationship between the parties. In the other instance, undue influence would not be presumed by law, but it was open to a party to establish an evidentiary presumption of undue influence. Actual undue influence. In such cases, the claimant must prove that the wrongdoer actually exerted an undue influence upon the complainant to enter into the transaction in question. In these instances, the criteria are: first, that the party to the transaction, or a person who induced the transaction for his benefit, has the capacity to influence the other party; 2, that he did influence the other party; 3, that the excess of this influence was undue; and 4, that it was because of this influence that the transaction was brought about. In a situation of actual undue influence, it is not necessary to show that the transaction was manifestly disadvantageous to the party subject to the undue influence. See Lloyds Bank v. Bundy in 1975. In CIBC Mortgages v. Pitt in 1993, a husband put pressure on his wife to agree to a £150,000 loan being taken out on the house they jointly owned in order to buy shares. The husband encountered problems with repayment of the loan after the stock market crashed in the late 1980s, and the bank attempted to repossess the house in order to recover the amount of the loan. When the bank attempted repossession, the wife argued that she had only agreed to the loan because of the pressure that had been placed upon her by her husband. The undue influence in question came from a campaign of sustained pressure rather than a particular threat. At trial, the court was satisfied that this course of conduct was such that amounted to actual evidence of undue influence. The campaign of sustained pressure overcame her initial objection to the purchase. Presumed undue influence. Here the claimant need not prove that there was actual undue influence. These situations, according to Lord Nichols in Royal Bank of Scotland v. Ettridge No. 2 in 2001, may arise in one of two ways. In the first case, the law makes a genuine presumption of certain defined types of relationship, such as doctor and patient, solicitor and client, trustee and beneficiary, a religious advisor and disciple. Since the Ettridge case, a finding of the existence of one of these relationships places the parties in a protective situation where the presumption of influence cannot be rebutted. Merely the finding that the influence was undue is under consideration. To allow otherwise would call into question the validity of the relationships present as they are said to be relationships that always conform to the same type. The burden of proof in establishing the presumption of influence lies with the party claiming undue influence. In the above situations, once that burden has been discharged, this presumption of influence is fixed and cannot be discharged. This is the consequence of the way in which the specially protected classes are now regarded in the wake of the Ettridge case. Several categories that do not give rise to this automatic presumption but may fall into another category instead. This is because these are situations where it is possible to prove that there is a close relationship of trust and confidence, but it should not be automatically assumed from the existence of the relationship. These are husband and wife, banker and customer, employer and employee. By extension, one could logically consider all marriages, since the Marriage Same-Sex Couples Act of 2013, as well as civil partners, cohabitees, and anyone else in an intimate personal relationship. See Future Loans Limited versus Julianne Porter from 2015. In these second type cases, there is a shift in the evidential burden of proof from the complainant to the other party to show that the transaction was made without improper influence. For this situation to arise, two elements are required. Firstly, that the complainant and the other party acquired ascendancy over the complainant. Secondly, that the transaction is not readily explicable other than as resulting from undue influence. In other words, the complainant may prove that the de facto existence of a relationship under which the complainant generally reposed trust and confidence in the wrongdoer, the existence of such a relationship raises the presumption of undue influence. See Barclays Bank v. O'Brien in 1994. The burden of proof, then, shifts to the alleged wrongdoer to disprove that they did not exercise undue influence, which is done by establishing that the complainant acted independently and understood his or her actions. In Annulment Funding v. Coe from 2010, the Court of Appeal found that actual undue influence and evidence-based presumed undue influence could be considered as alternatives by the court. This case concerned a man who was declared bankrupt but who had jointly with his partner, the amount of which more than covered the amount of debt that had led to the bankruptcy. He engaged Annulment Funding, a company that specialized in annulling the bankruptcy of its clients by loaning them the amount required to pay off their creditors in bankruptcy in the form of a bridging loan. This is a short-term loan used until the now discharged bankrupt client can obtain a mortgage on their property to pay back annulment funding. In Mr. Coe's case, the mortgage broker was unable to find a mortgage, and so Annulment Funding took action to recover the amount of the bridging loan by repossession and sale of the house that Mr. Coe and his partner jointly owned. Mr. Coe's partner argued that the agreement had been entered into regarding the bridging loan was subject to Mr. Coe's undue influence, and argued for a presumption to be set up of undue influence that would need to be rebutted by Annulment Funding in order for them to be able that there was enough evidence to establish a case of actual influence, and found on that basis. It also held that even where a party argues for a finding of presumed influence on the basis of evidence, the court is at liberty to find that actual influence had taken place on the basis of that evidence. And as there had not been enough evidence to demonstrate actual influence, presumed undue influence could be used as an alternative. How to avoid the presumption of undue influence? In the later cases mentioned again, the burden is upon the party claiming influence to establish a presumption. However, this is done through evidence of the relationship at hand to demonstrate that trust and confidence exists. This therefore leads to a presumption that one party has influence over the other. This is where these cases are different from the automatic presumption ones discussed earlier. The burden here is reversed, and it is then up to the other party to rebut this presumption of influence. This can be done most effectively by showing that the other party was not in fact induced and entered into the agreement freely. So, if you're accused of unduly influencing somebody's decision to enter into a contract with you, the most effective way of rebutting the presumption that you have influence over them, such as they have trust and confidence that they made their decision independently, maybe through showing that they had independent advice. This would therefore demonstrate that the decision made was one that was fully informed, based upon independent advice, and not solely upon influence caused by the other party. You should note that the concept of manifest disadvantage is no longer useful in analyzing instances of undue influence. Lord Nichols in Ettridge commented that the transactions of a more unusual nature, for example an unusually large gift, would call for further explanation. The actions of an employee towards their employer in putting their house up as collateral security for the overdraft of the company in Credilio Netherlands vs. Birch in 1997, which would cause a bank manager to raise his eyebrows more than a little, gives some insight into the meaning of something calling for an explanation. This approach of the House of Lords is under the idea of manifest disadvantage, and relied more heavily upon the judgment of Olcart v. Skinner of 1887, where the court proposed the idea that where a gift is so large as not to be reasonably accounted for on the grounds of friendship, relationship, charity, or other ordinary motives on which ordinary men act, then it is down to the person receiving that gift to provide an explanation. The intervention of a third party gives rise to difficulties. In practice, most litigation occurs where the relationship of undue influence arises between A and B, whereby B enters into a contract with C for the benefit of A. The most common instance of this scenario is when the relationship of undue influence exists between spouses and one spouse induces the other to enter into a transaction with a bank. The most common way in which the bank can rebut the possibility of undue influence is by notice, meaning to inform the spouse as to the nature of the transaction. In Barclays Bank v. O'Brien in 1993, a wife had entered into an agreement for a charge to be placed on the matrimonial home to guarantee the overdraft of the husband's company. The transaction took place at a different branch to the one that the couple usually went to, and therefore O'Brien's bank manager had left instructions for both parties to be fully appraised of the current state of the overdraft and to advise them to speak to their solicitor if they had any concerns prior to entering the agreement. Unfortunately, the branch did not follow their instructions, and therefore the wife was unaware of the extent of the overdraft. She thought that it was for £60,000, when in reality it was for £135,000. When the company's overdraft reached £154,000, the bank attempted to repossess the house under the legal charge that it had placed upon it. The wife claimed that she had entered into an agreement and attempted to get the transaction set aside. The court discussed policy considerations with a growing number of cases involving wives, but rejected the idea of some sort of special protection for wives or others in similar relationships, mainly because this might give a shortcut back to an automatic presumption of undue influence for such parties. The court found that the transaction was of such a nature that, in order to avoid being fixed with constructive notice, the bank would have to demonstrate that certain steps had been taken by them. Constructive or legal notice is a presumption that the party has notice when it can discover certain facts by due diligence or inquiry into the public records. A party found to have constructive notice cannot deny knowledge of a fact because that party did not have actual knowledge, since there is a duty to conduct due investigation. Guiding the bank to appropriately handle there is potentially dangerous power or knowledge mismatch between the parties relies upon the bank being put on inquiry in certain circumstances. These circumstances were, first, the transaction is on its face not to the financial advantage of the wife, and secondly, there is a risk in transactions of that kind that in procuring the wife to act as a surety, the husband has committed a legal or equitable wrong that entitles the wife to set aside the transaction. If it were subsequently shown that there had been undue influence, the bank would have constructive knowledge of the undue influence unless they could show that they had taken reasonable steps to establish that the wife had entered into the transaction freely and knowing the facts. The court held that, as this had not happened in O'Brien, for instance, the bank had constructive notice of the undue influence and could not repossess the family home. The judgment of Lord Nichols in Ettridge provides guidance on the matter of avoiding constructive notice. The bank needs to make sure that a solicitor is named by the wife and that this solicitor is instructed to advise separately to the husband. This can be the same solicitor that your husband uses, but the wife must be given the opportunity to nominate a separate solicitor. The solicitor must advise the wife on the nature of documents and practical implications of signing them. They must also explain that the wife will be legally bound by the documents once signed. As the bank are in the best position to explain the financial situation, they must either do so or pass on all the relevant financial data to allow the solicitor to properly explain the situation. The solicitor's role is then to advise and confirm in writing that this has taken place. Without the written confirmation from the solicitor, the bank should not proceed with the transaction. Even if it later transpires that the wife was subjected to undue influence, if these steps are followed, then the wife will not be able to use the undue influence. As with duress, the main remedy for undue influence is to make the contract voidable at the victim's discretion. Therefore, the ability to rescind the contract is available. As discussed earlier for duress, if no rescission has been applied for, this can be deemed to be constructive affirmation of the contract and remedies will no longer be available. See the Atlantic Baron case. In Olcott v. Skinner from 1887, the plaintiff had joined a religious group called the Sisters for the Poor. while under the influence of her spiritual advisor. During her time as part of this group, she had given approximately £7,000 to the religious leader. She left the group, and 6 years after having left, she attempted to reclaim the money that she had paid. The court found that the long delay between leaving the order and claiming the money could be construed as being a constructive affirmation of the contract, and she was not entitled to recover the money. It is useful to remember that undue influence cases are not only about disputes arising out of intimate relationships. They can be very much commercial in nature, as evidenced in the Libyan Investment Authority versus Goldman Sachs International from 2016. In this case, Justice Rose dismissed a claim by the Libyan Investment Authority in which it asserted that Goldman had exerted undue influence over its employees, which resulted in it making improper investments and which in turn caused losses of $1.2 billion. Goldman denied these claims and contended that first, the relationship did not go beyond an ordinary relationship of banks selling investment products to a wealthy client, and second, Libyan Investment Authority, being a sovereign wealth fund, was a more sophisticated investor than it claimed to be. Duress and undue influence can have a significant effect upon a contractual agreement because they render a contract voidable at the discretion of the victim if proved. Duress is available at common law, whereas undue influence is an equitable doctrine, to be applied at the discretion of the court where appropriate. These two areas are considered an important part of the law of contract because contractual agreements are supposed to be made through the free will of the parties. Duress and undue influence are considered vitiating factors because arguably they interfere with the ability of a person to freely and willingly enter into a contract. When considering the effect of finding of duress or undue influence, it is important to consider the impact upon parties to the contract as well as third parties involved. The law has attempted to engage in a balancing act between the rights whose will has been vitiated and a third party who may also be innocent in the situation yet is burdened with a duty to discharge, as is the case with banks. This is a dynamic area of the law, with new cases frequently coming before the courts. In summarizing the points we can address the following questions. We are considering in which of the following situations there will be a finding of duress or undue influence. Anthony agrees to sell his car to Brian for a fraction of its value after Brian threatens to harm Anthony's children. This will be an instance of duress to the person. A threat of physical harm forces the other party to agree to a contractual deal. See Barton versus Armstrong from 1976. This would have the effect of rendering the contract void at the insistence of Anthony. Magnus Property subcontract complex plumbing work to a large construction project to Crazy Pipes. Half the plumbing work has been done when Crazy Pipes realize that Magnus are in financial difficulties and are desperate to get the building finished. Crazy Pipes threaten to pull out unless Magnus increased the price by 10%. Magnus agree, realizing that they are unlikely to get another plumbing firm capable of finishing the work in time. This is a more complex scenario that involves potentially economic duress. There is a clear threat to break the contract, not an unlawful demand, but one that would class as an illegitimate pressure, and no practical alternative for Magnus. See the Universe Sentinel from 1983. This scenario will remind you of the seminal case of Williams versus Roffey from 1991 on practical benefit consideration. But the financial weakness here is the other way around, with the main contractor, not the subcontractor, facing problems. Also, there was no threat in Williams. The main contractor initiated negotiations. This scenario would present problems with finding consideration to support the agreement to provide the same work for a higher price, as practical benefit duration cannot be found alongside an instance of duress, lest because the other party does not actually receive any benefit by paying the extra money. As we have established, the presence of an illegitimate threat, if Magnus agreed mainly because of the threat that Crazy Pipes would pull out, they will be able to void the contractual amendment. A possible defense by Crazy Pipes would be to deny that the threat led to the decision to alter the contract and that there were other pressures external to them and that Magnus could have found an alternative provider. Considering precedents such as Barton versus Armstrong, however, this is unlikely to be a convincing argument. Xavier, who is very hungry coming back from an evening clubbing without his wallet, agrees to give his smartphone to Jonathan in exchange for a sandwich. He regrets his decision after having consumed the sandwich. The key point here is seeing that nothing unlawful has been threatened. In fact, is there a threat at all? It is clear the arguments as the requirements aren't met. This may be an ill-advised agreement on the part of Xavier, but any issues may have to do with other aspects of formation, perhaps with the intention to create legal relations. Perhaps Xavier was inebriated and lacked capacity to enter into the agreement. Overall, however, the problem isn't linked to duress, and duress of circumstances isn't a civil law doctrine that can be used here. It is a criminal law concept, and even there, wanting a sandwich would not be enough. Tabitha has recently been widowed. Tabitha trusts a traveling preacher, Mr. Jones, to establish communication with her deceased husband. Mr. Jones tells Tabitha that her husband wishes her to donate £10,000 to Innocence Limited, a company Mr. Jones claims is involved in valuable charitable work. Tabitha donates the money by gift under seal. 3 months later, Tabitha discovers that Mr. Jones is the director and sole shareholder of Innocence Limited. She comes to you for your advice. Tabitha is seeking the return of the £10,000 donation to Innocence Limited. She cannot simply ask for her money back as the gift was made under seal, which does not require consideration to create obligation. This will be a case of undue influence. Tabitha could argue that she made the donation under the actual or presumed undue influence exercised by Mr. Jones. To prove actual undue influence, Tabitha will need to establish unfair and improper conduct or coercion from the outside, or cheating leading to some advantage taken, as in Olcott and Skinner. If Mr. Jones knows of Tabitha's recent bereavement and susceptibility to psychic influences, then he is using her reliance on him for advice for his personal advantage. Having established that the relationship of trust and confidence existed, Tabitha will need to prove that she made the decision to proceed with the donation under the insistence of Mr. Jones. Undue influence renders contracts voidable, and Tabitha needs to seek court assistance within a reasonable time, otherwise influence is affirmed and the claimant loses. However, 3 months have elapsed, but Tabitha could genuinely claim that she only became aware then of the impropriety of Mr. Jones' actions. To rely on presumed undue influence may be difficult for Tabitha. This is not one of the special cases described in O'Brien, so Tabitha will need to show that a special bond existed and that the transaction looks inexplicable under normal motives, as in Ettridge, for the presumption to arise. If it arises, it can be rebutted by Jones by showing that Tabitha received independent advice or acted on her own motives spontaneously. Considering that Mr. Jones appears to be somewhat of a scammer, Tabitha may have a good case of actual undue influence she could use in challenging her donation. This presentation dealt with the contract law topics of duress and undue influence. First, we dealt with duress, introducing the doctrine, and addressing the possibility of duress to the person and/or goods. Then, we spent some time discussing the potential for economic duress. On the topic of undue influence, first we introduced the doctrine, and then we discussed the separate cases of actual undue influence and presumed undue influence. We also discussed the effects on third parties and the remedies that are available.